So, yeah, I totally forgot to hit the record button. So the first few, stuff in this recording probably won't make it to YouTube. Sorry, YouTube. Um, like as you know, I will record these on Twitch. Twitch allows me to keep these for 2 weeks on the site on the channel, and then I'll upload some to the um to the um to the YouTube page that I've created. Okay, shall we talk about international humanitarian law? So this is a topic that's very close to, I guess, my specific expertise. It's what I wrote my first book on, and what I used to teach in Peru. It's been some time since I taught this. Oh, thanks for subscribing, Bernhunk. Hope you like the subscriber emotes. And it's a topic that is like close to what I do. It's like when I was in uh, Peru and I was like growing up. There was a lot of discussion and debate about whether what was happening in Peru or had happened in Peru at the time when I was born. I was born in '85. Peru had an armed conflict. Had a very big crisis with the Shining Path, a terrorist group that launched an attack on Peruvian democracy. Um, there was a lot of discussion about whether that was an armed conflict or not, and whether international humanitarian law should apply to the situation. And so I basically I grew up and did my entire law school with this in my mind, trying to learn and figure out, is this an armed conflict? Because in Peru it was very controversial to say that it was an armed conflict, but as we discussed in the previous episode on national reconciliation, the Truth and Reconciliation Commission in Peru had decided that what had happened between you know 1980 and 2000 was an armed conflict. And so I really wanted to know. I got into law school in 2003. I started law school in 2003, and I really wanted to know what the law had to say about this. So I got into international humanitarian law, trying to understand what had happened during my childhood and whether it was an armed conflict or not. And so this was quite a big of a personal issue for me. Eventually, in my first book, I conclude that Peru did go through an armed conflict, and from then on, like I did a master's on international human rights law that included international humanitarian law. I returned to Peru after my master's to teach IHL, IHL for short, international humanitarian law. So again, it's a topic that I'm very passionate about. I really like studying it because it helps me understand what was going on in my own country when I was little. Um, and I guess so. I know that the main reason why we are going to discuss this is because of the recent um, revelation statement by the Gaza Ministry of Health that 40,000 Palestinians have died in the course of the um, ongoing catastrophe that is Israel's operation in Gaza and their um, their reaction, their retaliation for October 7th. But I do think it is important to approach this topic first from a technical perspective. Like, let's learn international humanitarian law, and then we can apply it to the specific context that we are studying. I think it is important to approach the law passionately, but not necessarily um, only thinking of one scenario, because these rules, international humanitarian law, these are dangerous rules. They are essentially, to apply international humanitarian law is to accept that peace and peaceful coexistence has broken down, and that we need to acknowledge and accept that people will resort to violence, they will kill each other as a means to carry out whatever policy they are carrying out. And therefore, while human rights law, like everyday normal human rights, are premised on the idea of let's protect people essentially at all costs, like use of force in human rights law is supposed to be the last resort. If you don't have any other option, any other way of dealing with something other than violence, that's the only scenario where you can use violence. In international humanitarian law, since we accept that this only applies when we cross a threshold of armed conflict, of war, of that kind of level of violence, then we accept that people will resort to force, not as a last resort, but sometimes as a first resort. So it is a very weird, strange body of laws, of rules, that we need to treat with care, with respect, and with a little bit of fear. What I like to what I used to tell my students in Peru is this is the first point of analysis. It's not the last one. Just because I tell you that something is valid under international humanitarian law does not mean that it is advisable, that it is good, that it is nice, that it is moral. Many legal acts under international humanitarian law can be profoundly immoral. And so it is a body of laws that is different from other bodies of law, other regimes of law, because law is usually premised on protecting people, and this one is more or less concerned with not just protecting people, but also enabling the conduct of hostilities. So essentially, if you're a pacifist, if you believe that war should not exist, international humanitarian law is your worst nightmare, I guess, because it is a body of law that says war is going on. So let's accept that fact and you know regulate regulate that fact as best as we can, which means that we accept that people will die, that people will shoot at each other, that civilians will die, that combatants will die, um, and that we cannot just regulate this through human rights law alone, because the bonds of coexistence have crumpled down. Right. So be mindful that this is the world where we're going into. Don't mean to interrupt. I'm sorry. Just wanted to ask: does international humanitarian law make any assumptions about human nature? Says Burhunk. Please don't feel bad about interrupting. Uh, this this is not a lecture. The whole point of the channel is for me to be able to engage with you guys outside the context of a ivory tower where I'm in a university and like we cannot discuss these topics um, you know face to face or however you want to chat to face. So please don't apologize for asking questions. Um, I think international humanitarian law um, makes has a claim or argues that it is, let's say, working towards humanity, like achieving humanity in war. That is the claim of international humanitarian law. There's a famous phrase that people who study international humanitarian law like to repeat, not necessarily one that I like to repeat, but they claim that war, that the regulation of war is a delicate balance, usually delicate balance between military necessity and humanity. And so you want to be as humane as possible, but also recognizing that there are things that you just need to do, which is not something that I really subscribe to. I think that may have been the case in the 19th century, and we can talk about the history of IHL in more detail some other time. In the 19th century, yes, the most important thing in conflict was achieving the objective of the war, and then being humane was sort of like a something that happened when you fought war. So there's a famous phrase by Francis Lieber, the so-called father of international humanitarian law, an American Prussian scholar during the Civil War in the United States, that said, "Sharp wars are brief." What did he mean by that? He means like the way to make war the most humane possible. This is in the 1860s. Um, is by making them sharp, by making them as brutal as you can, so that they are fast and don't last long. So the faster the war is, the more humane it is. The more protracted a war is, the less humane it is. That's a 19th century mentality. I wrote my PhD on this, so like I can talk about this for hours. I don't subscribe to that view. I don't think that the shorter war is the more humane war. I think there is no such thing as a humane war. Um, and this 19th century mentality actually needs to be abandoned in favor of a new, more modern, more post-colonial vision of international humanitarian law, where the purpose of the rules is not to achieve some kind of like balance between what you need to do to win the war and, well, let's be humane to prisoners of war. No, the purpose of this law is, as its very name suggests, to be humanitarian. So it should be an obstacle in the way of not necessarily an obstacle, but almost an obstacle in the way of an army. It should be there to protect civilians, and if it encumbers the conduct of hostilities, well, then that's tough luck, because we need to protect civilians. It should not be military necessity that is the foremost concern of these bodies, of these rules, but what's in their name, humanitarianism, should be at the core concern. And this is a process that is taking centuries, from Lieber in the 19th century to today. There still are many specialists in international humanitarian law, including many military law experts and many armies, that still subscribe to this like Liberian view of international humanitarian law. And there are other scholars like me and like some friends of mine that I really admire and really respect, like Adil Haq and like Tom Dannenbaum, and people that will say that protection of civilians and protection of the vulnerable is what's at heart of these rules. Okay, that's what I believe. I believe international humanitarian law needs to be humanitarian, or then it is not international humanitarian law. That's why you'll see a division between people that talk about this, between those who say international humanitarian law, like me, and those who say the laws of war, because the laws of war regulate war. International humanitarian law tries to achieve humanitarianism. So that's a long answer to a short question. Sorry about that, but yeah, that's how I would answer your question, Burhang. But so what I what I want to do today, with the goal of having some sort of uh, I'm glad that was thankful. I'm glad that was helpful. With some view of like not approaching this based on specific facts, based on we are angry at the fact that 40,000 people have died. So how do we rationalize that in legal terms? I want to explore this first from the perspective of theory, and then we can apply it to the facts, so that we don't fall into any kind of like confirmation bias, and we understand the rules, and then we can apply them. Then we can apply humanitarian principles to the news. Okay, I think that's a better alternative than what usually happens, say, like on Twitter, where like you need to like react automatically to everything. Right? You need to react, and then the broader picture disappears. Right? So let me then start. Oh, and one more thing that I was like trying to that I was trying to discover. I now know how to add little images here and there um, in my, how do you call this, my screen. So I will be able to put images here and there in my screen. That'll help. They'll be helpful going forward. Hopefully this can eventually become like a very interactive, very one-to-one sort of like, I don't want to say class, but like space, learning space, where we can come and like I can learn from you, you can learn from me, which is what a class should be, honestly. Um, but yeah, so now I can put little images around the screen. So it won't look very pretty because like my design skills are zero, but it'll be helpful for you guys. Okay. So let's start, right? Um, so I guess the first place to start is, when is there an armed conflict? Like from what point on do we stop applying the general rules of international human rights law? Well, not stop, but like at what point do we incorporate the rules of international humanitarian law to the rules of human rights, because we accept that peaceful coexistence can no longer um, apply or exist, or are no longer useful, right? So this is relatively easy when it comes to states. When two states go to war, that's called an international armed conflict. And whenever there's recourse to force between two countries, then you have an armed conflict, right? That's the general very simple rule. So when is there war between two countries? Well, when one of them launches an armed attack against another, and then they clash. So when, I don't know, when Nazi Germany started sending tanks to Poland, then there's an armed conflict because there's a imminent recourse to force, and Poland is going to defend itself. And so that will cause um, the specific rules of armed conflict to apply. Bernhunk asks, does an armed conflict have to be announced or for it to be considered active internationally? So this is where this is a very good question, because originally, like in the 19th century, wars needed to be declared. I don't know if you've heard the phrase like, this is a casus belli, this is a cause for war. Like someone would come with their glove and slap you in the face and it's like, this is war, and then leave. Um, that is how war worked before the introduction of the concept of armed conflict with the Geneva Conventions. When the Geneva Conventions popped up, and they essentially, people could not agree on what was a war, so they instead agreed on a different concept of armed conflict, both international, referring between states, inter-nations, international, or non-international, meaning between a state and a non-state armed group, right? Nowadays, you do not need to declare war. Nowadays, before then, there was a we can talk about some other time, but yeah, before you technically you needed to declare war. Um, there's there's a interesting paper by Professor Una Hathaway and Scott Shapiro. They describe all the manuscripts, all the declarations of war throughout the years, and you can read that. It's really really interesting. But yeah, no, an armed conflict, an international armed conflict between two states does not need to be declared. It's just it exists from the moment when there is recourse to armed force between two states, right? So um, it's a little bit different when it's not one state and another state, but it's a state against a non-state armed group, or between two non-state armed groups between each other. So let's say a civil war or a guerrilla insurgency, or I don't know, you name it, whatever situation you can conceive of when there is one non-state armed group facing against a state or another armed group, right? In those circumstances, the standard for application of international humanitarian law changes. It's no longer any recourse to force, because we don't want to say that if, let's say, a demonstration turns violent, um, and the police needs to use force, then any recourse to force between a non-state group and the state would be that you no longer need to apply human rights law. Arguably, you want to apply I mean, not apply, but like human rights law would need to be interpreted in line with humanitarian law. That you would need to incorporate humanitarian law, and you don't want to do that because you don't want to apply a war paradigm on violent demonstrators. You want to arrest people that protest violently. You don't want to execute them, right? So you don't want to have a situation where um, what is called like internal disturbances become a war for the purposes of the law, and you end up shooting a bunch of people that are not really engaged in an armed conflict. And there's a lot of discussion about like um, what is that threshold? At what point can you say that the conflict is intense enough? And so the tribunal, the criminal tribunal for the former Yugoslavia, in a case called Prosecutor Vitadic, gave us what is probably the most authoritative definition for what is a non-international armed conflict. And they said that whenever there is protracted armed violence between a state and a non-state armed group, or between two non-state armed groups between each other, right? Um, so this definition, protracted armed violence between a state and a non-state and an organized non-state armed group, has two elements, right? One, the violence needs to be protracted. It cannot just be like um, someone slaps you in the street. It needs to last for a period of time, which means it needs to be of a specific intensity. So people protesting violently don't generate an armed conflict. And therefore humanitarian law does not apply to them. You don't want to send tanks to a demonstration, right? The second requirement is that the non-state armed group needs to be organized enough. It cannot just be a amorphous rabble of people just causing chaos. They need to be able to speak with one voice. They need to have some kind of a hierarchy, be organized, right? Um, and this is this is something that has come up when we have been playing The Last of Us. We play The Last of Us on Wednesdays, and we discuss The Last of Us from the perspective of the law. And one thing that we always talk about is the apocalypse where all the zombies are there. Is that an an armed conflict? And the answer we gave, if you want to check the past videos, is no, it's not an armed conflict because the zombies are not organized enough. They're just walking there, and they don't coordinate with one another. Right, so the zombie apocalypse cannot be an armed conflict. You cannot apply international humanitarian law, and so you can only apply human rights law. Right, that's a silly example, but like a practical example. Right, so if you have protracted armed violence and so intense hostilities and an organized armed group, then you can apply international humanitarian law. And so the rules of international human rights law um, would need to be interpreted in line with international humanitarian law. I'm sort of simplifying for the sake of an introduction to IHL, but that's generally the main idea, right? Um, so what does it mean for there to be an armed conflict in principle for international humanitarian law to apply, right? Burhunk has another question. So what's happening right now in Bangladesh classifies an armed conflict in your view? I'm more or less aware of what's going on in Bangladesh, but I don't have enough information to make that kind of determination. Um, it sounds to me like an internal disturbance. I don't think there's enough to go on about saying that there's an organized armed group and sufficiently intense hostilities, but I am not an expert in this topic. I am not entirely sure. So I wouldn't want to make a determination like that. Um, so Les Strumpf says, "Hi Alonso, this may be a topic that could have its own whole stream, but could you speak to IHL in respect of climate change? Is IHL prepared for the massive displacement of peoples we are likely to see over the course of this century?" Uh, okay, so I will make a caveat here. This allows me to differentiate international humanitarian law from humanitarianism. Humanitarianism would be the set of principles and organizations that work to advance uh, and protect humanity from these kinds of disasters. International humanitarian law would rather focus on the climate effects of conflict. So, are you destroying the environment in the course of your hostilities? So, if you, I don't know, say you destroy a dam or you start using like depleted uranium and there's a lot of depleted uranium in the ground, or I don't know, stuff like that. It's uh it's a different focus. But yeah, it could be its own stream to begin with. So I will not get into that right now. But yeah, in general, um the focus would shift if you're talking about humanitarianism and humanitarian actors and IHL. Right? IHL would focus on whether a war is having, it's a ecocide, for example. You're destroying the environment and thus causing a harm in order to defeat an enemy. Right? That is something that would concern IHL. So okay, so we can conclude then that we know when IHL applies. At that point, what does that mean? What does it mean that IHL applies? And there's a very simple way of understanding this. If a British citizen goes to a beach in France um, and kills someone there, grabs a gun and kills them, um, that counts as murder. That is, of course, murder, illegal, unlawful, immoral, right? Um, but if that same British national is a member of the armed forces of the United Kingdom during World War II, and he is disembarking in Normandy and he is shooting at German soldiers, then the application of international humanitarian law to that armed conflict grants that person something that is called a combatant's immunity. The, it is a privilege that says that when a member of an armed force attacks another member of an armed force, that is not murder. you are immunized from domestic law and you no longer commit murder. Remember, when two states are, so in an international armed conflict, right? So this is why uh, in war movies and everything, there's no police arresting Tom Hanks for trying to rescue Private Ryan, because he kills people on the way to find Private Ryan. That's not a crime under domestic law. The only crimes that you can commit in the course of that war are war crimes. In those war crimes, um, you are you're violating not domestic law, which is immunized because of the application of international humanitarian law. You are violating international law. You're violating international law. What does that mean? It means that you are attacking a civilian or are attacking someone who's out of combat, like is no longer part of the hostilities. You are violating international humanitarian law. I have a glare in my eyes. So I'm going to close this. Um, if you violate international humanitarian law, then you commit a war crime, but not a domestic crime, right? Okay, so this doesn't translate equally to a non-international armed conflict. In a non-international armed conflict, since there are no two states, you cannot put them, let's say, at the same legal level and say your criminal law will not apply to me and my criminal law will not apply to you. Doesn't really compute that way, because one of the parties is a non-state armed group. They don't really have the capacity to grant this kind of immunity. There are proposals to make sure that they do, but that's like lege ferenda. That's like what some people want the law to be, not what the law is. Right now, um, both domestic law and international law would apply, and that means that a soldier that is engaged in an armed conflict, say in a civil war with a non-state armed group in their country, um, does not commit a war crime if he kills a militant of the other side in the civil war, because it is not contrary to international law to kill people that are engaging in direct participation in hostilities. More on that in a second. But that soldier will likely also be not held responsible for murder and under domestic law because he's a member of the armed forces, meaning that he's authorized by domestic law to use force. That's why he's being deployed. Right? That's not the same with whoever is taking up arms against the state. A non-state armed group that rises up in arms, you sort of like rise up in arms taking a risk, taking a legal risk, right? That if you engage in hostilities, that engagement in hostilities will be illegal under the law of the state that doesn't want you to rise up in hostilities. So a member of a armed group that attacks a soldier doesn't have permission from domestic law to attack that um, that soldier. So they commit a crime under domestic law, but they don't commit a war crime because international law allows you to, attack the other member of the armed forces. So while there is no immunity from domestic law in um, non-international armed conflicts, so those who rise up in arms do commit domestic crimes. They also don't commit international crimes. They don't commit war crimes for rising up in hostilities. So generally speaking, the difference is that when you have two states at war, domestic law doesn't apply for criminal law purposes. And when you have a non-international armed conflict, domestic law sort of like applies unfairly, let's say, unequally to the belligerents. But international law, the law of international humanitarian law, that applies equally to both parties. Both of them cannot attack civilians and people who are out of combat, or in French is the legal term is in French, or de combat. I don't speak French. I probably murdered that word. But so what happens is, under international law, they can attack each other. They just cannot attack civilians or people that are not engaged in combat. Okay, that's the general basic premise of how this works. And I want to make sure that people are with me here. Like if there's any like doubt, anything wasn't clear, just let me know and I can explain it in more detail. Um, because this is sort of like the foundation of how everything works. All right. So um, where I will once you know how this that this law is applying and how this law applies, that's when we can start talking about the rules of targeting. Right? So, yes, it's very easy to say you can only attack those who are participating in hostilities. Okay, what does that mean? Right? What does that mean? Oh, you can only attack combatants. Great. What does that mean? Right? You cannot attack civilians. Okay, who's a civilian? Who isn't a civilian? What are we going to do about it? How does that work? Right? So it gets more complicated if you start digging into it because I mean the basic rules are simple, but the implementation of the rules are more complicated. Right? So let's start talking about the rules of targeting. Right? Once you know that you're in an armed conflict, um, who can you shoot at? Right? And of course, just bear with me for a second here before we move forward. If we're going to talk about Israel Palestine, a huge question in the conflict between Israel and Hamas is what is it? Is it an international armed conflict or is it a non-international armed conflict? On the one hand, there are those who say that it is a non-international armed conflict because it is a state and a non-state actor. Hamas is a non-state actor. They're not the state of Palestine. Others will say that it is an international armed conflict because um, you have Israel occupying the state of Palestine, and therefore that creates a situation of occupation um, that creates an international armed conflict, and then Hamas would be a group that is acting on the side of the state of Palestine, and so they would be part of an international armed conflict. And then others, including the ICC prosecutor, for example, will say, no, no, the armed conflict between Palestine and Israel is one conflict, that is an international armed conflict, where Israel is occupying Palestinian land, so that is an international armed conflict, there's recourse to force between two states. In that scenario, that the one that would have immunity, combatants immunity, is the Palestinian state and the Israeli state. The other party in that conflict would be Hamas, which would be acting on its own non-international armed conflict against the state of Israel. Right? So there would be two conflicts happening at the same time, one international and one non-international. Israel Palestine would be international, Israel Hamas would be non-international. And I have my own view. I happen to agree with the ICC prosecutor that there is an international armed conflict between Israel and Palestine and a non-international conflict between Hamas and Israel. But this is by far not a settled question. And bear that in mind. Different people, different scholars, highly respected scholars, people that I really admire, will disagree on this a lot. It is not settled. Okay, so some people will say that it is only a non-international armed conflict, which I think is the weakest of the arguments. Others will say that it is only an international armed conflict, and where Hamas is an armed force that is, let's say, part of Palestine, with which I tend to disagree with. And then others will say that there's two conflicts at the same time. Okay, so um, Burhung says, why isn't there a category specific to occupied relationships? I mean, there is, because occupation of territory is usually considered an international armed conflict. Because usually to occupy territory, you need to be a state. If you are a non-state armed group and you invade someone else's territory, that is not um, usually generating such a situation as to qualify as an occupation, because usually there's no that kind of like control, like quasi sovereign control of a territory. So usually, like we would say, occupation triggers an international armed conflict. It is regulated as a type of international armed conflict. But of course, reality is a bit more complicated than whatever you can put on a piece of paper. So um, there's this weird situation with Israel Palestine where Palestine is not recognized as a state by every single actor involved, particularly Israel. So um, can it really be an occupation if one of the parties is not a state? That's Israel's argument. Right? Israel says it's not an occupation. Of course, that is not correct. It is, of course, an occupation. The International Court of Justice has already said so. Um, but yeah, there is a specific category for occupations. It's called international armed conflict. The law of occupation applies the rules of international armed conflict as if it were between two states. Razanov says, why not both? Yeah, um, that is basically what he's doing. Like, it's why not both? Thanks for the Spanish. Actually, it's always refreshing. Um, So where were we? Oh, one more question. Boulevard of Dreams says, recently, after an Israeli attack on a school, I read a tweet claiming that even if Nazis had been in the school, it would have been illegal. But wouldn't it have been legal as the school would have been used for military purpose, and an attack would therefore be legal under the Geneva Convention? This is an excellent question, and I can answer it in a bit when we discuss targeting, because otherwise it'll get a little bit confusing. Okay, but I will get to it. If I don't, remind me. But I've planned to discuss this. Okay, so bear with me for a second, and then we'll deal with that. Um, so yeah, just so we can go in order, and people don't get lost along the way. Okay, so in terms of conflict classification, my position is that there is an armed conflict between Israel and Palestine. It's an international armed conflict between two states. Of course, not everyone sees Palestine as a state, but I still think it's a conflict between two states. As a military occupation, then it's also an international armed conflict. And I say then in that scenario, there is one non-state armed group, organized non-state armed group that is engaged in protracted armed violence against the Israeli state, Hamas, and so that generates a separate non-international armed conflict with Israel. Um, that is not the only view. I want to make it clear. There are others that will say that Hamas is part of Palestine. I just happen to disagree with that. Right. So now that we know what is an armed conflict and how the rules of armed conflict apply to the hostilities between two groups, in this case Israel and Hamas, as a non-international armed conflict, we can then look at the law of targeting. Once you are in that conflict, who can you attack? Who can you go after? Right. So in general, when war is between two states, when you have an international armed conflict, you shoot based on status. You kill the people who have a specific status under international law. That status is being a member of the armed forces. So soldiers from the UK could shoot at soldiers from Germany during World War II. Why? Because they were, you know, members of that armed force. That's generally how it goes. Um, and there's a problem when the two sides that fight are not both states. Because in non-international armed conflicts, who is a member becomes very confusing. So who gets to be a member of an armed force? Who gets to be targetable, right? So um, this is because technically speaking, we are dealing with international humanitarian law, so a body of laws that is meant to protect civilians. And technically speaking, this non-state armed group is composed of civilians that took up arms. So it's composed by the people that you're supposed to sort of like protect from war. So what do? Right? How do you solve this problem? So this is where I'm gonna make use of my first image here. I hope you can see it. I hope it is big enough and clear enough. I think so. I'm looking at the Twitch channel here, and I think it is. This is Article 51 of Additional Protocol 1 to the Geneva Conventions. Okay? Um, you don't need to read it all. You can if you want, but you don't need to. I will read you the key parts. Okay, so Article 51 is the one that deals with how to protect civilians in armed conflict. So it very clearly states that the civilian population and individual civilians shall enjoy general protection against the dangers arising from military operations. It's paragraph 51(1), right? Um, Essentially saying that international humanitarian law is humanitarian, right? It protects civilians. In paragraph 2, you got the provision that says that the civilian population as such, as well as individual civilians, shall not be the object of attack. So you cannot just say, I'm going to go kill those civilians. That is illegal under the laws of war, international humanitarian law. Right? Acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. So if you want to terrorize the civilian population for the sake of terrorizing them, that is illegal. That violates the principle of distinction. You need to distinguish between the civilian population and those people that you are fighting against, right? So you cannot, under any circumstance, target a civilian. And paragraph 3 is the key point that we're discussing. And this is the key for a lot of what you will see in the media about, Israel Palestine. 51.3 says civilians shall enjoy the protection afforded by this section unless and for such time as they take a direct part in hostilities. What does this mean? Right? This generated a lot of discussion in scholarship. Like, what does it mean that civilians enjoy these protections only unless and for such time as they take direct part in hostilities? So, essentially, what this says is you as a civilian are protected while you remain a civilian. From the moment that you take up arms and directly participate in the hostilities, then you lose that protection for as long as that participation lasts, right? So that became the very critical question. How long is that? Because of course um, you have a scenario where someone grabs a gun and shoots at a soldier, right? Um, Without that person necessarily being a member of Hamas or the Islamic Jihad or the Shining Path in the case of Peru, they just want to protect their plot of land and they saw soldiers and they used force against those soldiers, right? For such time as that person has that gun in their hands, they are not afforded the protection of being a civilian. Right? So from the moment that they reach for the gun and grab it and and attack, then they lose that civilian protection. And then once the civilian drops the gun and says, "Whoa, whoa, I'm sorry, I didn't realize that you were a soldier," and that, I'm sorry, then that civilian can no longer be attacked. From the moment where the participation in hostility starts to the moment where it ends, that civilian can be targeted, but no further. Okay, that is the basic, essential reading, the most textual reading you can get from this section. But it can get even more complicated. Um, so Burhank says, is the you here the particular person, or does it apply more generally to groups? So right now I'm discussing an individual person, right? An individual person that grabs a gun and shoots at a soldier is taking direct part in hostilities. So what? But it can get a lot more complicated, right? Because of course, um, not everyone just has this occasional participation in hostilities. Not everyone just grabs a gun and starts fighting. There is another armed force. There is a Shining Path. There is a Hamas that's engaging in protracted armed force against soldiers, right? So in that case, it became a lot more complicated for militaries to decide, okay, what does for such time mean? Because does this mean that there's a military engagement between a member of an armed force that uses force against a soldier and then leaves and then goes back to being a farmer by day, let's say, right? Farmer by day, fighter by night. Does that mean that the soldier can no longer use force against that person while he's acting as farmer? Does he need to wait for him to grab a gun, even when he knows that he has a gun and that he's a member of an armed group and that he might be, willing to shoot preemptively at the soldier? So it gets more complicated. We'll get to that in a second. We'll get to that scenario in a second. Razanov says, but how can the ICC or ICJ judges investigate or falsify claims of a state that their intelligence shows that civilian targets was used for military purpose, so they blew up the place? We'll get to that. We'll get to that. This has to do with Israel's claims that they've killed 17,000, Hamas members. We'll get to that. Let me get there. Like I said in the beginning, like let's understand the theory and then let's apply it to the specific case. Okay. Um, so so this is the definition of when a civilian loses protection. Article 51 of Additional Protocol 1 of the Geneva, Additional Protocol 1, additional to the Geneva Conventions, paragraph 3. Okay, so, but what does participate in hostilities mean? Like, sure, participate in hostilities, grab a gun and shoot, but it can get more nuanced and complicated, right? Is, let's say, engaging in propaganda, going to on a radio and saying, yeah, we need to support the non-state armed group and fight against the government. Is that participating in hostilities or not? It can get tricky. So before we go into what happens with armed forces, like fighter by night, farmer by day, let's first define what DPH, direct participation in hostilities, is. Edward SVM. In the American Sniper movie, the sniper talks to himself, telling the kid to put the weapon down so he won't need to shoot him. Right. Okay. So I personally like. I think by now you guys know that I love movies. And I it's one thing that I would like to do actually. Like if there's a movie out there that has a relevant international law content, I can just log on for a few 30 minutes or so and just analyze it from the perspective of international law. If that's something you would be interested in, just let me know. But yeah, I personally don't like the American Sniper movie mostly because of that kind of rationale. I mean, um, like I said, the IHL is the beginning, not the end of the equation. But yeah, looking at it from the perspective of the movie, like inserting myself in the movie, then yeah, what he is saying is that child, what the American Sniper is saying, I forget his name, but what he's saying is that child is a civilian, right? He's not a combatant. But if he merely grabs a a weapon, all of a sudden that kid, that child, becomes a combatant. So what he's saying is, kid, don't directly participate in hostilities. And what I want to posit here as a question is that directly participating in hostilities? Or is that sort of an excuse to shoot a child? When can we say that there is direct participation in hostilities? And even if he like grabs the gun, is that direct participation in hostilities, right? So, in order for us to answer that question, I have another convenient little image. I'm very proud of the fact that I can do this now. Um, so um, this is called the constitutive elements of direct participation in hostilities. This I took out from the interpretive guidance on direct participation in hostilities from the ICRC. You can get it free of charge from this website that I'm going to put on the chat, and I'm going to be excited about it because you're going to learn stuff. So I'm going to use my new emotes. So if you click there, I know it says shop, but if you click there, you can get it free of charge if you download it as a PDF. Okay, just select the option I want a PDF, and the price tag will go down from 5 Swiss francs to 0. Right. So in that document, which is a document that the International Committee for the Red Cross, the sort of like safekeepers of the Geneva Conventions, use to define what is direct participation in hostilities. It is not binding. It is not a treaty, but let's say it carries weight because it is the ICRC that is doing it. Um, so this is what they said. Um, they said that in order to qualify as direct participation in hostilities, a specific act must meet the following cumulative criteria. Number one, and this is called the threshold of harm. meaning that the act must be likely to adversely affect the military operations or military capacity of a party to an armed conflict, or alternatively to inflict death, injury, or destruction on persons or objectives protected against direct attacks. Uh, against direct attacks. So this is the question of the little child picking up the gun. Does the sheer mere act of picking up a gun cross the threshold of harm? Hmm. No, there's no harm, at least not yet, right? Um, so this is also like it comes up in like the Israeli-Palestinian conflict with the idea of a teenager throwing a rock at a tank. Does that cross the threshold of harm? I would argue no, because nothing will happen to that tank. If someone slaps a soldier in World War II, that doesn't mean that that civilian loses its protection as a civilian and therefore needs to be shot because they slapped a soldier. That doesn't cross the threshold of harm. The threshold of harm has to do with there needs to be a danger to the life of the combatant. If you follow me, like it needs to be more than just like ouch. If it's an owie, it's not enough. It needs to be harm in the military sense of harm, right? So throwing rocks at tanks arguably does not, you know, cross the threshold of harm. A little kid picking up a weapon, not even knowing what to do with it, doesn't cross the threshold of harm. So that would not be that is a required element for someone to be participating in hostilities. Right? They need to actually cause harm or be likely to cause harm. Right? The act must be likely to adversely affect the military operations or military capacity of a party to an armed conflict, meaning it needs to encumber your movements or your tanks or whatever, or it needs to inflict death, injury, or destruction. Have the must be likely to inflict death, injury, or destruction on persons or objects. So if a little kid that has no idea how to use a gun just grabs a gun, that doesn't necessarily make them a member of Hamas or something, right? So bear that in mind going forward. Can it be that a kid becomes a combatant, or not becomes loses his civilian protection? Yes, of course. There are child soldiers in the world. I just don't think that a 5-year-old picking up a gun is the same as a child soldier. This is the kind of thing that make me not like American Sniper as a movie. I think the moral of the movie is a little bit too lenient with like, oh, I had to do these horrible things, but it's war and war is hell, so war legitimizes whatever I want. That's just not how it works. Um, Second constitutive element of participation in hostilities, there must be a direct causal link between the act and the harm likely to result either from that act or from a coordinated military operation of which that act constitutes an integral part. So basically, there needs to be direct causation. What does this mean? It's very simple. Um, Whatever harm has to be directly caused. So, for example, if I was talking about the propaganda factor. Um, if someone says uh, stuff in favor of a particular armed group, and that leads someone to join the resistance or join the armed group, right? The person who promoted that propaganda has not directly caused the harm. So there's no causal link. There's no direct causation. Therefore, that person did not participate in hostilities. This is something that happened in the United States in the case called Anwar al-Awlahi. I'm gonna put it in the chat so that you guys can look it up. Anwar al-Awlahi v. United States. Um, so in that case, a cleric, an American cleric, I don't remember where exactly. I think it was in, I don't know if it was Pakistan or Yemen. Um, but an American cleric was saying things in favor of Al Qaeda, and they did a targeted strike and killed him. So his father sued the U.S. for wrongful death, and he lost because the court said that this was non-justiciable. Like you had no recourse if the government killed your son. So it was a messed up case. But if I'm analyzing this from the perspective of what counts as direct participation in hostilities, there's no direct causation between words and harm, right? So that doesn't count as direct participation in hostilities. That's the general, you know, claim, the general meaning of direct causation. And yes, Magic of Carols, absolutely. The movie totally justifies war crimes and is about a war criminal. I tend to generally agree that that's how the movie represents, the situation. I really don't like that movie. I think if you wanna find movies that are more, um, I guess, better at representing war, then yeah, I would say Saving Private Ryan. I would say The Thin Red Line. I would say um, Eye in the Sky, like I said in another video. What other good war? Hacksaw Ridge is great. Um, there's um, there's a bunch of good war movies. I haven't seen All Quiet on the Western Front yet, but I want to. So yeah, we'll look into that. Um, so those are, I guess, movies that discuss, the same things that American Sniper wants to discuss but fails at discussing. Okay. Oh, Jens, how are you? Grave of the Fireflies. I don't know that one, but seeing as you are ducking, it must be, a complicated one. Um, I don't know that one. I'll look into it. But welcome. uh, that's a depressing movie. Oh boy. Okay. Extremely traumatic Ghibli movie. Oh. Is this the one about the atomic bomb? Is it the one about, what happened after the atomic bomb? Was only shown in cinema with Totoro. Oh, I'll look into it. I think I know which one it is. Yeah, yeah. I'll look into it. And sorry that my image is blocking the chat. But I can read your chat here separately. Anyway, the third element of direct participation in hostilities is called belligerent nexus. Oh, firebomb. Okay. So belligerent nexus is that the act must be specifically designed to directly cause the required threshold of harm in support of a party to the conflict and to the detriment of another. So it's not just enough that you directly cause harm. It has to be harm in the context of a war. Right? So if you rob a bank, you are directly causing harm. But you're not directly causing harm to support, let's say, the Shining Path. So you are not directly participating in hostilities by robbing a bank. You see how it gets nuanced? It's a lot more nuanced than the law, the text of the rule suggests. Right? So this is why we have so much discussion about this. So generally, then, it is direct participation in hostilities if you create enough harm in a direct fashion connected to one of the parties of the armed conflict. Done. That's direct participation in hostilities. Okay, so you lose protection as a civilian for such time as you do that harm with direct causation and with a belligerent nexus, um, and then you recover your protection when you stop doing that. So if a civilian grabs a gun and starts shooting at someone, then that is direct participation in hostilities. He's shooting at a soldier, directly shooting at a soldier, um, in in opposition to the army. Direct participation in hostilities. So he can be targeted. That person that grabbed the gun can be targeted for directly participating in hostilities, even though he is technically a civilian, um, because he's lost his protection. Right. So um, so what happens when it's not just someone who grabbed the gun? It is a member of an armed group that is like permanently embedded to a party to the conflict. How does the for such time component work? How does the for such time component work when it's someone that is like, say, farmer by day, fighter by night, right? Can they take advantage of what is called the so-called revolving door of direct participation in hostilities, where whenever you need to not be targeted, you become a civilian, and whenever you need to attack, you become a fighter? Armies have complained about this since like time immemorial. I think like the in the 19th century during the Franco-Prussian War, this was something that the Prussians complained a lot about the French franc-tireurs from where um, much of these debates come from. So it's a very old debate. Okay, um, and so the ICRC in this um, in this interpretive guidance on the concept of direct participation in hostilities, proposed a way out. What the ICRC proposed was, look, you lose your protection as civilian if you're a member of an armed force, if you have what they called a continuous combat function in that group. So essentially what they're saying is, let's assume that you have a very organized armed group, non-state armed group, like you are Franco in the Spanish Civil War. You have like battalions, you have uniforms, you like you are a very organized armed group, quasi-state. You are the Confederate South, let's say. And in your battalions, there's, you know, I don't know, Bruce. And Bruce handles the cooking. He's your cook. He peels potatoes, chops potatoes, boils potatoes, puts a sauce on top, gives it to your soldiers. That's what he does. Bruce the cook. He is a member of the Confederacy. He is a member of um, a non-state armed group. Can you still shoot him based on that fact? Meaning that if you see him, if you see Bruce, you can just open fire because he has a status. So you don't need to wait for him to be engaged in a specific attack. You can just shoot him. And that is where it gets tricky because the ICRC, the International Committee for the Red Cross, said no. Bruce doesn't have a continuous combat function. He has a continuous cooking function. He's not engaged in hostilities. So why would you shoot him? So a bunch of states, particularly the United States and Israel, objected to this and said, it's not my job to figure out if Bruce is a cook or not. All I need to know is that they are a member of the specific armed group, and so I can shoot them. But this, I mean, even knowing who is and who isn't a member requires some homework, right? There is a way that the United States engaged with Al Qaeda and the insurgency in Iraq um, that was called signature strikes. Because the United States did not know who was a member of Al Qaeda and who was a member of the Sunni insurgency, they just used signs, signatures, right? They said, for example, anyone wearing a black turban um, with a very fancy watch, which would not be available to uh, regular Iraqis, and that we suspect might be armed, qualifies as a member of Al Qaeda, and therefore we can shoot them, target and kill them. This is actually something that happened. In my opinion, these signature strikes are absolutely illegal. You are not even determining if someone is a member or not. You're just piecing evidence together, very ancillary, very indirect evidence, and concluding something about someone that's going to lead to their deaths. You should not be able to do that as an army. But that is something that the United States did. Um, Arguably, what the media is reporting that Israel does in Gaza is more illegal because it's the idea that if you order an evacuation, anyone who remains is a member of Hamas, and that's just not true, right? You can remain in place, sheltering in place for a variety of reasons. So that is not enough for you to say that the individual is a member of an armed group and therefore targetable not based on their actions, but based on their status as a member. That is why the ICRC said, well, but then let's let's narrow that down. If you have a continuous combat function, then you are targetable. But if you don't have um, that continuous combat function, then you can't be targeted in the same way as a soldier can. It's unfair. States reply, say, no, but my cooks, when I'm at war, they're part of the military, and so they are targetable. So a state cook in World War II is targetable, but let's say Shining Path cook in the Peruvian armed conflict is not targetable. That's unfair. But yeah, the situation is different because a how many times have you seen cartoons where the punishment for a soldier is to go peel potatoes, right? So if you're a soldier that knows how to cook, you're still a soldier, right? So you're still a member of an armed force that has gone like training and everything. If you're just a regular cook, then and you don't necessarily have that combat function that we're looking for. If you can prove that that cook is also a combatant, then you can shoot him, right? So this is where we're at, right? This is where we're at. Uh, the idea of a continuous combat function as the reason for you to become a target, right? This created a lot of controversy. The United States and Israel, for example, don't accept the notion of a continuous combat function. Like I said, they believe that if they deem you a member, then they can shoot at you. And this is someone asked me this in the chat. Boulevard of Dreams. No, it wasn't Boulevard of Dreams. Who was it? Someone asked me about the ICC. Oh, Razinov. Uh, how can the ICC or ICJ investigate or falsify claims of a state that their intelligence shows that civilian targets was used for military purposes, so they blew up the place? It's a similar problem, right? It's similar. They claim that a specific individual was a military target. This would require proof, in my opinion. Um, if you're planning an attack like this, you would need proof beyond the there is a they were wearing an expensive watch. You would need to have a case for declaring someone a target, or at least a set of circumstances that makes it obvious that they were. Like you were in the front lines and someone was shooting at you. Then of course, so that person is directly participating in hostilities. It really doesn't matter if it's through a continuous combat function or not. They're shooting at you. But there's a lot of very let's say, intense disagreement between military scholars and humanitarian law scholars on what exactly counts as membership in an armed force. Everyone seems to agree on the occasional civilian picking up a weapon, but not with membership. I subscribe to the ICRC view. I think if you don't have a continuous combat function, then given how radical and how aggressive this body of law is, it should be applied restrictively. It should apply to the least amount of people possible, not the maximum amount of people possible. We don't want people to be subjected to these body of law. That's my view. But I mean, take it as my view only, okay? And you don't need to agree with me either, of course. Okay, so that's targeting of people. But as we have seen, and like as Razanov asked, a lot of this has to do with objects. When does an object become a military target? And so this is where I have my other image. Here you go. This is Article 52 of the additional protocols to the Geneva Convention, the first additional protocol to the Geneva Conventions. And Article 52 says it's general protections of civilian objects. Okay. Paragraph 1 says civilian objects shall not be the object of attack or of reprisals. So you cannot decide to attack them or attack them in, let's say, revenge. Civilian objects are all objects um, which are not military objectives as defined in paragraph 2. So the civilian nature of an object comes from them not being military targets. It's a negative definition. If you're not a military target, you're a civilian object. So most things in war will be a civilian object and therefore protected. Okay, so the key paragraph here is Article 52 of Additional Protocol 1, paragraph 2. It says attacks shall be limited strictly to military objectives, like we said. Insofar as objects are concerned, so not applicable to people, right, military objectives are limited to those objects which, by their nature, location, purpose, or use, make an effective contribution to military action and whose total or partial destruction, capture, or neutralization in the circumstances ruling at the time offer a definitive military advantage. So this is the complicated way of phrasing that thing that you hear Israel say all the time about this was used for military purposes. This is the legal basis for that claim. Um, and it is very important to understand what this says and what it does not say. Okay, so what it says is that yes, if you have a civilian object, that civilian object can become a military target if it is um, used in a way that contributes to the military actions of another party to the conflict. Right. So, for example, um, an apartment complex, a flat an apartment complex, is not necessarily. It's not. No, it's not. Uh, by its nature, it's not a military objective, right? You don't construct a uh, a civilian apartment complex to win a war. It's say, for example, the Pentagon. The Pentagon, by its very nature, is a military target. Right? There's no way out of it. In between, you have, say, a bridge. You don't necessarily build a bridge to win a war, but you can use it, you know, for war to transport supplies. So if that bridge, since that bridge can be used to transport supplies, then you can target it as a military objective. But an apartment complex, a flat, is not by its nature or by its purpose a military target. It should be a civilian object, right? But what happens if I go into that apartment complex and then use it as a place to coordinate my military movements, or I store weapons in it? That means that that object can lose its protection under international humanitarian law. Um, but again, while it is being used, once it stopped being used, it can no longer be targeted. Right. So this is something that's happened a lot, and we will talk about this in further detail down the line. But like this is something that has happened with hospitals, where Israel claims that a hospital has been used for military purposes, so it attacks it, and then once it wins the battle, it uses the hospital itself for military purposes. That is not allowed. It's not allowed when um, Hamas uses it. It's not allowed when Israel uses it. Because once the use stops, then it's not a military target. It continues to be a hospital. So Israel should withdraw from the hospital and enable that hospital to return to be a hospital to fulfill its purpose. Right? So that's something that is just like very wrong in the understanding of military objectives in the Israeli army. That this idea that use is like a permanent stain on a civilian object. It is not. Once the object stops to be used, then it is no longer a military objective. Um, and so it is also very important, paragraph 3. In case of doubt whether an object which is normally dedicated to civilian purposes, such as a place of worship, a house or other dwellings, or a school, is being used to make an effective contribution to military action, it shall be presumed not to be so used. So if you don't know, it's civilian. And this applies to people as well. If you don't know, it's civilian. So you need to offer evidence of this use. It's not enough to say, oh, it's being used. You need for it to be legal, you need to say it's being used, um, and here's my claim, here's my argument, right? For it to be legal, if this goes to court, like for example, there needs to be a reason to say this is not, this is being used militarily. So this is what happens when you have when you determine that you can attack a civilian object. Let's say that there is a weapons cache in the basement of an apartment complex, right? So you have weapons there in that apartment complex. Can you target that weapons cache in that apartment complex? Yes, with a proviso. If you are attacking a military objective, you have already decided that you are distinguishing between civilians and military targets. So that's step 1. But that's not all. And this is another classical mistaken view, in my opinion, of saying, well, it was used for military purposes. There was an arms cache in the basement. Therefore, I don't need to comply with any other regulations. I don't need to do anything else. It's a free for all now. And that's just not how it works. Because once you determine that this is a military objective, you still need to comply with what is known as the principle of proportionality. So the proportional harm, the civilian harm caused by your attack needs to be proportionate to the military advantage gained by the attack. So you're destroying a few weapons. What does that warrant in terms of civilian casualties? I would argue very few, right? Because this is just a cache of weapons. They're just there. The military advantage of destroying a few weapons cannot justify killing, ending a civilian life. But many in the IHL community, particularly those that favor a more military necessity view of war, will say, no, no, there's an arms cache in the building. Therefore, the building is the military target, and therefore I can destroy the entire building um, because it's the entire building that is the military objective, not the specific basement where the cache is, right? And this is just, in my opinion, this is just inhumane. People shouldn't live in a situation where if someone in next door does something, um, you know, dangerous, then you can be shot by association. That's just not okay, in my opinion. You shouldn't target the entire building. And this is something that Israel has done in the past. It's destroyed entire buildings because of one flat having one set of military usage. Um, and again, this needs to be while it is being used for military purposes, right? So, for example, in this strike, where recently two 4-day-olds were killed along their mother and grandmother in an apartment complex, while the father was out, getting the birth certificates. There was no um, military use there. So that was not a well, that we know of at least. There was no military use there. Like the 4-year-olds were not coordinating attacks, right? So that was not a military object. Its use was not military. So that strike has to have been illegal. And then again, even if there had been military use, even if there had been someone in that flat, let's say, I don't know, that had a continuous combat function with um, in Hamas, there wasn't, but let's assume that there was, then is killing them, um, does killing them warrant also killing two 4-day-olds? I don't think so. I don't think that's proportionate. Okay, so um, it's not that, oh, military use, therefore no more obligations. I can do whatever I want. That's not how it works. Okay, and that is something that I think that is the biggest misconception about how international humanitarian law works that we've been seeing in the media. Okay, Telferl says, would you say Ukraine blowing up bridges that transport food to rural regions is a humanitarian crime? I would need to know more about the specific operation, because bridges, by their like almost by their nature, can be used for military purposes. So bridges are traditionally considered um, valid military objectives, so long that you comply, so long as you comply with proportionality, because they can hurt the military, um, the military objectives of your enemy. Now, of course, if this bridge is like the Golden Gate Bridge and is full of civilians and you blow it up, then you might still have an illegal um, strike on your hands. But if you just blow up a bridge and you take precautions not to kill any civilians, then yeah, uh, there's a valid argument for um, targeting a bridge. There's actually a famous case, the case of the Mostar Bridge in I think it was Bosnia during the Yugoslavian wars, uh, where or was it Serbia? I think it was. I'm not sure, but NATO forces targeted a bridge. And while you can Google Mostar Bridge in YouTube and you might find the footage. You can see the footage of the missile going against the bridge, and on the last second you see that there was a freight passenger train crossing the bridge, and no one knew. And so the bridge was destroyed, and the train was also destroyed. As far as long as uh, the attacking forces didn't know of this train, that would be a lawful strike. The problem is that then NATO forces shot another missile at the bridge, because the bridge did not collapse with the first strike. Now that they did, knowing that there was a train full of people that might have survivors, and they wanted to destroy that bridge so bad that they still shot the missile with that train of people there. That is not as legal. That is, in my opinion, that is a war crime. But of course, that is not. I mean, the when the International Criminal Tribunal for the former Yugoslavia looked into that case, they determined that it wasn't a violation of the laws of war. I disagree, but that's what they said. Um, Telferl, Ukraine have blown up two bridges in the region of Russia they have invaded, saying they have done it to stop Russian reinforcements coming into the area. However, in doing so, 10 remote villages can no longer get their essential supplies like food and bottled water. Yes, these are two separate obligations. One is the quality of the bridge as a military objective, which it is. But then the other one is the humanitarian obligations of Ukraine towards the civilian population. So Ukraine, as the occupying power in that area, just like Israel in Gaza, needs to make sure that these villages get their essential supplies. It is their responsibility, their obligations. If they don't, then they would be in breach of their obligations as an occupier. But the blowing up of the bridge itself is not. I would say, because I don't have enough data, is not necessarily in itself illegal under international law. It's always difficult to make these pronouncements when I don't have enough information. So when you ask me if is this legal or not, please don't take it as me giving you legal advice or not. Um, I usually don't have enough information to make such a detailed pronouncement. So I will tell you, maybe it's probable, or it's my opinion. Don't take it as me making, a definitive legal analysis, because I'm not doing that. Okay, so um, we have done now the Article 52.2. Telfrel says, "No, I understand. It's just your opinion on the situation without the full information." Yeah, yeah. It's fine to ask. I can give you my opinion. Isn't it scary that all of this is so open to opinion and interpretation? Yes. That is why I said in the beginning that this is a horrible set of laws. Like, it is a set of laws that applies when we accept. I'm gonna remove this. We apply this law when we accept that peaceful coexistence is no longer possible. When we fail is when we apply this. So there's a great book by Samuel Moyne. Let me see if I can find it. It's called Humane. Uh, what the book argues is that the rules of international humanitarian law are actually sort of like bad, because what they do is they normalize, they regulate, um, you know, war. This is the link to the book if you want to read it. Um, and uh, instead of focusing on banning war, we have focused instead on humanizing, quote unquote, war, which is of course impossible. You cannot have a humane war. That's the title of the book, Humane. Um, so there are those who argue that humanitarian law is actually not humanitarian at all, because the most humanitarian thing that you can do is ban war. So pacifism over humanitarianism. This is a view that I completely support. I do think that the end goal of all of this needs to be to end war, because there's no way to regulate war in any kind of humane way. It is just too chaotic for us to be able to do that. So why do we? Right? Telfel says they will never ban war. America will lose half its GDP on gun sales. Lol. Yeah, I mean, I'm not saying it's easy, but it should be the end goal. The end goal should not be to assume that we can humanize war. I don't think we will ever humanize war. There is no such thing as a humane war. There's only brutal, horrible, immoral, awful, arguably illegal war. Burhunk says, I forgot which philosopher it was who suggested that war itself is a crime, no matter the context. Let me see. So there is a Argentinian scholar from the 19th century. This is something that you'll see happens often in the history of international law. There's people that no one knows about that said stuff before um, Europeans, who wrote a book called The Crime of War, El Crimen de la Guerra. He's called Juan Bautista Alberdi. I will put the book in the comments for you guys, and you should check it out because he said it before anyone else. Hold on, here it goes. So yeah, this is El Crimen de la Guerra by Juan Bautista Alberdi. It's in Spanish. It's a really interesting book. It's from the 1870s, um, saying that yeah, war is by itself a crime. Cheryl says that war is legalized killing, as far as I'm concerned. I mean, it's literally that. It's legalized killing. It's absolutely true. Which is why I find it so abhorrent and I hate it. Um, but okay, we're talking about like the nature of civilian objects, right? And when does a civilian object become a military target? And we have discussed how these military targets um, can only be attacked in very narrow circumstances, and it's not a free for all. It's not just because you apply, just because you can say that an object has been used militarily doesn't mean that that object becomes a military target forever. It becomes a military target for such time as it is being used. Um, and this brings me back to the example um, of hospitals. Right? There's one final image that I have prepared for you guys. This is a really cool way of doing interactive teaching, actually. Let me see, image 4. So this is Article 13 of Additional Protocol 1. It's a little bit on my face. Let me move here. So Article 13 is the one that deals with what is called medical units. Medical units are structures, vehicles that have a humanitarian function to heal people. Okay, so a hospital would be a military, a civilian medical unit. Oh, Professor Traques, how are you? Have you talked about proportionality and distinction already? Got here a bit late today. I have. You'll find that in the recording. Don't worry about it. Um, but we can. I mean, if you have any questions, just ask them, and we can talk about it as well. No problem. Thanks for showing back. For showing up again. By the way, you're like my a very loyal viewer. I really appreciate that. If you arrived late, then you probably missed that we have new emotes. If you want to use emotes since you're a subscriber, you can try them out. Uh, so Article 13 of the additional protocol. This one is specifically to explore the protections of hospitals and ambulances and medical units. Okay. Um, and this is very important in the context of the discussions we've had of has this hospital been used for military purposes or not in the context of Gaza. Okay, and you see how we started at the very oh, I'm still in my face, the very most general point possible, and we have narrowed it down, and now we're talking about more specific stuff. Okay, that was what I was trying to accomplish. So in that regard, successful lecture. Um, so Article 13 says the protection to which civilian medical units are entitled shall not cease unless they are used to commit outside of their humanitarian function acts harmful to the enemy. Protection may, however, cease only after a warning has been given. Uh, a warning has been given setting whenever appropriate, a reasonable time limit, and after such warning has remained unheeded. Okay, so this means that medical units are not your everyday normal civilian objects that can turn into a military objective because of their use. There are heightened protections because we don't want to have a war against hospitals. We don't want to destroy, at least the law doesn't want you to destroy every single hospital in a specific area. Right? So there are additional protections in place for this so that this does not happen. Okay? So it says that the protection to which civilian medical units are entitled shall not cease and then, unless they are used to commit outside of their humanitarian function acts harmful to the enemy. Right? Once these things, these units, these objects are used for military purposes, then you need to give a warning and say, please stop. Uh, and then you need to set up a time limit. You need to leave by XYZ time. And then only after that is not complied with, then you can attack. This is a very heightened protection. Okay. Now, there's an additional protection in Article 13, Section 2. It says the following shall not be considered acts harmful to the enemy. Remember, we have established that you can attack a medical unit if it is used for acts harmful to the enemy. But acts harmful to the enemy is a narrower concept than use. So it says the following shall not be considered as acts harmful to the enemy. A, that the personnel of the unit are equipped with light individual weapons for their own defense or for that of the wounded and sick in their charge. This means that if you have an ambulance and you see an armed person in an ambulance, that alone is not enough for you to say that that ambulance is being used um, for military purposes. Because what if that person that is armed is equipped with light individual weapons for the protection of the ambulance? Right? So just a video of you seeing someone with a gun in an ambulance is not enough for you to say that that ambulance is being used for military purposes. Right? That it's that much higher the protection given to medical units because we really don't want you to do this. Right? Vicious Chicken of Bristol. Oh, awesome! Great city, Bristol. I like what you do with statues of colonialists. Vicious Chicken of Bristol says, uh, talking about the protection of civilians, terrorists are legally civilians too, aren't they? Okay, so this is a. Before I get distracted, I'll get back to that question. But just to give you a short answer, terrorist is a concept that has no definition under international law. It only has a definition under domestic law of each specific state. So, under international law, a civilian that participates in hostilities through acts of terror would lose their protection. That is true. But terrorist itself is not a category of international humanitarian law. Terrorism is a way of engaging in hostilities in these treaties that is banned. Remember when we read in the beginning, we read that acts meant to target that the civilian population would be banned. That's because the additional protocols to the Geneva Conventions ban terrorism as a weapon, as a means and methods of war. But the definition of who is a terrorist is not something that IHL is concerned with. IHL is concerned with defining a civilian and a combatant. And if a civilian engages in terrorism, they can become a combatant, essentially that. Right? Professor Trakis says that kind of depends on whether you have ratified additional protocols 1 and 2 to the Geneva Conventions, which would allow you to recognize them as combatants if they gather some specific characteristics. Yes, that is true. Elsa is right. In IHL, there are only two categories of people: civilians and combatants. Yes, thank you, Professor Trakis. This is super useful. I sort of like that the chat can get a life of its own. You guys can talk amongst yourselves. This is part of the reason why we want a Discord channel. I'll get to it. Don't worry about it. So yeah. Shell Benson, just a reminder that international languages is English regarding the links you're sharing. Is there any way to download the screenshots that you have in your talk here? So unfortunately, for example, that book is not translated. so I cannot share it in English. You say that English is an international language. Yes and no, because it's an international language in the sense that I can communicate with you in English, but it is not an international language in the sense that a lot of the stuff that I studied with is in Spanish. No one knows that it exists, and no one that speaks English with enough means to translate into English even cares about translating them. So it is an international language, sure, but it is also a barrier of access to a lot of knowledge out there in the world. So I don't want to just share English sources in this channel. At some point, if there is something that doesn't exist in English, it doesn't become invisible. It just becomes your duty to engage with it in whatever way you can. Right. So when I was doing my PhD, I don't speak French, and I had to use French sources. So I had to like learn a little bit of French and also use translation services and talk to people who spoke French to be able to use those sources. Because it is just, I mean, I'm sharing with you a source that not a lot of people are even aware of in the English speaking world, right? So, um, yeah, yes, English is a international language, but it very much is also a barrier of access to knowledge, because if it's not in English, it doesn't exist, and that's something I don't want to reproduce in this space. If you have something in a language that I don't speak that you think is valuable, by all means share it with us and explain it to us, and maybe we can find a way to access it. But let's just not make it invisible because it is not in English. Um, so Professor Trackes, my students have a hard time with international criminal law, for example, because Crier and others are only available in English. Maybe AI can hook us up. So I agree with Professor Trackes. I also struggled with like sources for. There's a lot of like this is something that happens. I'm sidetracking a lot. I'm sorry. I'll go back to hospitals in a second, but this is important. There's something that happens in Spanish-speaking academia that doesn't happen in English-speaking academia that sort of bothers me. Spanish-speaking journals translate stuff to Spanish because we need to use them. So a lot of journals in academic journals in Spanish will translate materials that are in English to Spanish so the Spanish speakers can access them. That is something that English journals don't do. And so English journals don't get translated materials and publish them from Spanish into English. And that is just unfortunate. Right? So something to bear in mind. On AI, Burhunk, sure, but then also AI is very exploitative of third world labor. So just be careful with that, and it's not that accurate. So I would say there's a responsibility for like journals out there to like translate material. Um, Cheryl, yeah, I know it's just I know you mean nothing bad by this. I think it's a good opportunity to just bring this topic up because yes, I hear this like English is the universal language a lot, not just from you. I'm not trying to like single you out or anything like that. It's just something that is just it's a recurrent theme as someone who's not a native English speaker. So I thought I would bring this up. Um, Bernhard, it's fine. I'm again. I'm not trying to make you guys feel bad by saying stuff like this. Um, so, please don't take it the wrong way. I'm just trying to like share my thoughts on this. I don't particularly like AI. I think it can be useful for personal use, but when you use AI for like something like this, where I'm like, you know, I don't know, using this to transmit knowledge and like, or you use it to make money, um, it's always easier to pay artists. Like I could have just gone to an AI and done some emotes for you guys with AI, but that would have been bad, and I would have never met like Miyuki Bunny, who made our awesome new emotes. Um, so so yeah, I'm careful with AI. I missed that the chat keeps cutting out. It could be my internet. Oh, I'm so sorry. It must be because my connection is good right now. Um, Dick White IRL thumbs up. Um, okay, let's go back to hospitals, shall we? So, medical units do not become military targets just because there's someone with a weapon in them. You need to discern whether that person is there with a light individual weapon to protect the ambulance, or if they are like using the ambulance to go to the I don't know to like perfidiously set up an attack. So I've seen these videos of like, oh look, there was an armed man in an ambulance. Legally, that's not enough. Rasova Tolerance says, when can we expect the arrest warrants by the ICC? I would say in a so the deadline is fast approaching for the victims to submit their um, their comments, and then um, the court needs to you know study this. So I would say weeks. I hope not months. But let's go back to hospitals. Um, so it says B. Another thing that is not considered harmful to the enemy. Okay. B. That the unit is guarded by a picket or by sentries or by an escort. So it's not just enough that there's an armed a doctor with a gun is not enough, right? Because it might be for personal defense, right? But even if it's a member of an armed force that it is escorting the ambulance, that's also not enough. You need to discern whether that ambulance is being used to harm you or if there's just a picket or an escort by an armed force. So if there are, let's say in World War II, there are German soldiers accompanying an ambulance because to protect it, that's not enough to attack the ambulance, right? That the ambulance doesn't become a military target. C. That small arms and ammunition taken from the wounded and sick and yet handed to the proper and not yet handed to the proper service are found in the units. So essentially, yeah, you're an ambulance in a war zone. There will be weapons in your ambulance. That does not turn the ambulance into a military objective or the hospital, right? And D. That members of the armed forces or other combatants are in the unit for medical reasons. Of course, if you are healing a member of the Shining Path or Hamas, that doesn't mean that you can attack the ambulance and say, "Oh, it's proportionate damage," right? Because I mean, he was a military target, or they were a military target, and so there were only two doctors there. So yeah, I shot him. No, they were there healing him. So that's not enough. That's healing someone is not an act harmful to the enemy. So um, I think it's the main conclusion from this is that it is so incredibly difficult to make a case that a medical unit is being used for military purposes that it should be practically impossible to launch a full-scale attack on medical units. That it's happened to every single hospital in Gaza is almost like inconceivable. Um, is it impossible? No, it is possible. There are scenarios where you are allowed to use force against the hospital, but you have to do it with such care that the kind of like devastation that we have seen in Gaza hospitals should not be allowed. Even more so when like the structural integrity of the hospital is being targeted, and so at the end of the operation, the hospital can no longer be used as a hospital. That's that's not okay. Um, the humanitarian function of medical units needs to be protected, right? So, um, we have done essentially a crash course in 2 hours of what is IHL. This is, I think, essentially this is what a very basic introduction. We can talk about this for like an entire semester, of course. So you're not experts in IHL yet, but it is a solid primer, let's say. At this point, do you have any questions that you want me to answer? Any specific things that I may have left out? Are you still curious about something? Um, I don't know. Uh, any other, like anything that might have happened uh, recently? And again, I cannot make legal pronouncements here. I don't own truth. It might be that I don't know, or that I don't have enough information. But we can discuss these things going forward today. So let me know. Okay, let me know if you have any questions. Because this was very fun, to be honest. Edward says, "What will it likely be command control, or would individuals be looked at in the Israel-Hamas conflict? Do you think, or both? Um, Sorry, can you expand on your question? I'm not sure I get it. Jens says Article 51 AP, Article 56 AP1 would be interesting. Let me go find it. Uh, you said Article 56 AP1. Hold on. Protection of works and installations containing dangerous forces. Oh crap. Okay, this one's difficult. um, so yeah, I don't have an image, so you can't read it with me. But if you want to, you can access it here. Uh, okay, so the article says, got it here. Let me find it here. Works or installations containing dangerous forces. This is Article 56, paragraph 1. Works and or installations containing dangerous forces, namely dams, dikes, and nuclear electrical generating stations, shall not be made the object of attack, even where these objects are military objectives, if such attack may cause the release of dangerous forces and consequent severe losses among the civilian population. Other military objectives located at or in the vicinity of these works or installations shall not be made the object of attack if such attack may cause the release of dangerous forces from the works or installations and consequent severe losses among the civilian population. The special protection against attack provided in paragraph 1 shall cease a. For a dam or a dike only if it is used for other than its normal function and in regular, significant, and direct support of military operations, and if such attack is the only feasible way to terminate such support. B. For a nuclear electrical generating station, only if it provides electric power in regular, significant, and direct support of military operations, and if such attack is the only feasible way to terminate such support. For other military objectives located in or in the vicinity of these works or installations, only if they are used in regular, significant, and direct support of military operations, and if such attack is the only feasible way to terminate such support. In all cases, the civilian population and individual civilians shall remain entitled to all the protections accorded to them by international law, including the protection of the precautionary measures provided in Article 57. If the protection ceases and any of the works, installations, or military objectives mentioned in paragraph 1 is attacked, all practical precautions shall be taken to avoid the release of dangerous forces. Essentially, what this article says is um, you cannot destroy a dam because then that will release the river. This would be an interesting thing to discuss. Did Treebeard in The Lord of the Rings commit a war crime when he released the river at the end of the Return of the King? No, at the end of the Two Towers. Treebeard releases the river and floods Isengard. So the general reasoning here is that for uh, protecting civilians, you should not release these dangerous forces unless it is the absolute final way of dealing with something. And I would say even then, you shouldn't just destroy a nuclear reactor and create a nuclear death cloud for military necessity reasons. So this is contentious because it is not clear because not all states, the United States and Israel, have not ratified this treaty. So it is not clear whether this article is actually customary in nature and therefore applicable to all states or not. So the United States and Israel believe that it is not, and most other states, I would say, think that it is or that it can be. Right? So I think it is absolutely imperative for this article to be customary, um, because it is very important to prevent these like massive harmful disasters. Right? So we are seeing a lot of this in the Russia-Ukraine context, where there's a lot of fighting around nuclear facilities, and parties need to make every effort not to release nuclear waste into the atmosphere. Um, let's see. Razanov says maybe not IHL, but on Palestine and the ICC, an argument I've seen made by some Amici is that the state of Palestine could not possibly be bound by Oslo since Israel agreed with the PLO and not with the state of Palestine. What do you think about this argument? Seems almost too powerful to me. Um, so it is a it is an interesting one. I um so given that the state of that's an interesting question actually. Is the PLO um applicable to the state of Palestine and not instead just to the is the Oslo agreement applicable to the state of Palestine and not just to the PLO? That is an excellent question. I had not really I don't have an actual answer to that. It makes sense. It's a reasonable argument. I think it is a perfectly reasonable argument. My view of Oslo is that um, it cannot go against Jus Kogan's rules, so it cannot legitimize annexation. So it's more like I don't care what Oslo says. Oslo is secondary to the right of self-determination of Palestinians because it's a Jus Kogan's rule. So to me, Oslo is less important. It might exist, but it's not enforceable wherever it contradicts Jus Kogan's obligations. But your argument is a very interesting one. I like it. I'll look into it. Thanks, Razanov. Um, Deck White IRL says, quick outline of the difference between ICC and ICJ. This is a really simple one. ICC deals with criminal matters between um, related to people, individuals that commit crimes. If a person commits a war crime, that's for the ICC. The ICJ deals with general questions of international law from states. So if a state commits a war crime, then that's the ICJ. Um, if there's a disagreement between two states, that's for the ICJ. The ICC only deals with individuals. This is Chicken of Bristol. We'll have to rewatch from the beginning. Missed most of it, but thanks so much for doing. Hey, I mean, I'm really happy to do this. It's really fulfilling to me. I really like that I'm able to like talk about these things in a face-to-face context or a chat-to-face context. I think the Discord server will be super useful for you guys to continue discussing this while I'm not, on air. And it will be a nice source of like content for the channel. I am having a blast. I am really enjoying this. I hope that the channel can continue to grow. Please tell your friends so that they can, follow or subscribe. It helps me a lot. I'm having a blast, so thank you for being here. Edward says, will there be more arrests likely looking at individual IDF behavior as more evidence is looked at? I think there will be more arrest warrants coming up. I think this is just the beginning. Vicious Chicken of Bristol, well, it was in regular, significant, and direct support of military operations of Saruman, wasn't it? This is something that I find interesting. I'm wondering if you guys would find it interesting. If I grab a screen cap of that, like, I don't know, 30-second video of, Treebeard destroying the dam of Isengard, um, and then we talk about that from the perspective of international law. Would you like to watch that? Because then I'm risking a IP claim, because I'm not a big channel. So I would only do that if this is something that you guys really want. So let me know, because that sounds like fun to me. Edward, I have to leave. Oh, thank you for coming, Edward. Jens is explaining what the ACJ is, so awesome. Thank you for that. And less Strumpf, we need to drag Treebeard to the Hague to settle this. Actually, in the world of the Lord of the Rings, I think it would be Elrond's council, right? So that would be kind of biased. Burhunk, I assumed smaller channels would fly under the radar regarding copyright infringement. I don't know because I feel like a smaller channel would get more easily grabbed by the auto software that they use to track images. Um, Whereas most bigger channels have people assigned to them um, in Twitch or stuff, like because they're partners or whatever, so they can directly say, "Hey, I will be doing this, therefore don't flag me." Right. So right now, for example, I have 3 emotes that have been flagged for review. Because I don't know, because I mean, I told you what it was going to be, right? It's 2 little characters holding signs that say war and crime, so that you guys can say, "Oh, this is a war crime," whenever I'm playing video games. I guess Twitch might not, maybe doesn't like them, and we'll see what happens. But yeah, I don't think that would happen to a big channel that has like auto upload for their emotes. So I guess what I'm saying is the bigger we get, the more fun stuff we can do. So spread the word and let's make that Discord channel happen. I will let you know as soon as I have it so that we can do this. Jens says UK doesn't have the kind of fair use as US, though commentary should still work as defense. Yeah, but since Twitch is in the US, they sort of like, I don't know. I don't know how that works. I'm happy to look into it if it's something that you guys would like to do. I love discussing law in movies. I run a symposium on pop culture and international law for this very reason. So if we can do this like talking like this, that would be amazing. I Toby B says, I guess you would use a screen grab of the Ukrainian dam. Sure. Um, Look, this is something that is technically feasible. There's a channel, I think it's called Mended Light, yeah, where there's this psychologist that analyzes pop culture from a psychological point of view, and I think it's just fantastic. You should definitely follow it. It's on YouTube. It's called Mended Light. I would love to do something similar with law and movies. So let me know if that's something that interests you. Professor Trakas says, I was thinking about belligerent occupation and the additional protocols in the case of Gaza, specifically in regards to what the definition of a conflict is, international versus internal, and so on. Perhaps we can talk about how these things work. Yeah, sure. So we discussed this a little bit in the beginning, how to classify the Hamas-Israel conflict and how some people see it as a international armed conflict, and that's it, because then there would be a conflict, a military occupation, and military occupations are a type of international armed conflict. And in that conflict, then Hamas would be a armed force belonging to Palestine, and that's it. This is, for example, what RULAC, the rule of mm, the program on rule of law and armed conflict says. And others think that there's an international conflict between Israel and Palestine because there's a military occupation, and in my opinion, two states, so it's an international conflict. But then there is a additional non-international armed conflict between Israel and Hamas. This has a lot of like consequences for the purpose of litigation, ICC, and in general how you view what Hamas is in the context of Israel-Palestine. Um, I subscribe to the view that this is an international armed conflict between Israel and Palestine, and then there's a non-international armed conflict between Hamas and Israel. But this is just my position. You don't need to agree with me. This is not in Spanish. We would say no es pacífico, so it's not Pacific in the in the sense that not everyone agrees. So bear that in mind. This is just my view. Um, but yeah, that's how I would qualify this classify this conflict. Okay, so I think we've been here for 2 hours. I think this has been great. Just to repeat the housekeeping stuff, um, we have new we have new emotes. We have as of now we have 3 emotes. We have one little girl asking a question, one zombie playing video games, and one me excited. I'm gonna chat them now. So if you want to use them, uh, the little girl is free for use. The other two are in the subscriber tier. Um, and I have 3 more that are currently being reviewed by Twitch. So let's see what they say. Hopefully they approve them. The artist that made these awesome emotes is called Miyuki Bunny. She is a follower if you want to find her. Um, She's a follower of the channel. And she's a fantastic artist. She was super professional with this. I'm very happy that I was able to support a small artist with this. Like I said, I would not have liked to use AI with this because of the problems that we've discussed before. So yeah, I will tweet about her so you can reach out to her if you want to do like emotes for your own channel or whatever, or you just want art in chibi style done for personal use. Definitely reach out to her. And then I'm creating the Discord channel soon with the help of one of you guys, um, the Dead Alive one. So I will get to that soon enough. Sorry, I haven't had time to do that yet, but I will. So yeah, hopefully this has been um, good for you guys. You've had a good time. Again, the purpose of this channel is to learn from each other and to just get me out of the ivory tower so we can have an interesting conversation. Don't forget that on Wednesday I will be killing zombies, playing The Last of Us. Yeah, And other than that, unless anyone has any final comments, I will start ending the stream. I will leave it on for a few minutes so you guys can chat for a bit, and then I will end the stream. Okay, thank you again um, for coming here, and thanks Burhan for subscribing today. You're my only subscriber today, so thank you so much. I really appreciate that. It really does help. Um, and thank you to all the other subscribers. I have four more subscribers, so thank you for that. Um, and yeah, thanks. Hopefully, I'll hope to see you here often. See you on Wednesday to play The Last of Us, and hope you have an amazing rest of your Sunday. Thank you so much for coming. I really appreciate it. Bye. Oh my God, Jens, thank you so much for all those gifts. Amazing. I can't believe it. This is great. Thank you so much. I really, really appreciate it. Okay, now I'm going. Bye.